Hello viewers and friends. This is Dr. Kashinath Neharkar and I welcome you in my YouTube channel at lecture series on labor laws first. Friends, in this lecture we are going to discuss an important topic from Industrial Dispute Act, that is an award and its binding nature. Friends, you know what is the concept of award? Award in general means any award which is given to any person who is sportsman, etc. So award can be the prize, etc. But the award in the context of Industrial Dispute Act is something different. So we must know what is the concept of award. Say friends, in Industrial Dispute Act there are different authorities that are provided for the dispute settlement, and it is the responsibility of these authorities to give the decision on dispute which is referred to them. So whatever the decision which is given by the different authorities under the act, that decision is called as an award under the Industrial Dispute Act. So an award is nothing but the decision given by adjudication authorities, including arbitration under Industrial Dispute Act. So we must see what is the definition of award under Industrial Dispute Act. Friends, section 2b of Industrial Dispute Act defines an award, and according to this definition, award is an interim or final determination of industrial dispute by labor court, industrial tribunal, and it includes arbitration award under section 10a of Industrial Dispute Act. So friends, in brief, the award is nothing but what the final decision given by the labor court, industrial tribunal, national tribunal under Industrial Dispute Act. Their final decision or even any decision, any order which is issued by authorities during the pendency of proceeding before it can be called as award. So these authorities like labor court, industrial tribunal, national tribunal, it should hold the proceedings and conduct the investigation and shall finally decide the matter by giving the decision on dispute, and such decision will be called as award. So we must know what is the basic difference between award in a general and award as per section 2b of Industrial Dispute Act. So Industrial Dispute Act defines it differently. Now we must say what shall be the form of award. As you know, it is the responsibility of these authorities to give decision on a dispute which is referred to it. So what will be the manner in which the award shall be given? What will be the form in which the award of such a tribunal shall be given? Actually, the labor courts tribunal is required to send an award to government in a writing with signature of presiding officer. Though there is no specific form of award which is provided by the act, but whenever the authorities are going to give the decision, decision should be given in a writing, and that decision should be properly signed by presiding officers. So that award must contain all the information and records on the dispute and the decision on such dispute, and it must include any dissenting opinions also. So this is the form of award. See, as award is nothing but the final decision of court, decision of labor court, industrial court, etc. This should be similar like the decisions of general courts, but the decisions of general courts are the courts under civil procedure code that are given in a specific form that is provided by civil procedure code or the rules of courts. But here for industrial court, labor court, no, though there is no specific form is provided, but that decision should be given in a writing, that should be signed by the presiding officer, and that should provide all the information relating to what is the dispute, what are the evidences submitted by the parties, what the witnesses submitted by the parties, what the records that are submitted, and then what is the final decision of court. So this is the form of award. Then we must say next point that is also important to know, that is publication of award. See, you know what is the general purpose of publication. The purpose of publication is to make it known to public at large. So at least to those parties who are concerned with that dispute, or whose rights and liabilities are to be decided by that decision. So here it is mandatory for appropriate government to publish the award in a prescribed manner. So when the government receives the decision from appropriate courts, it is the responsibility of appropriate government to publish. That should be published in a prescribed manner, and the award must be published within 30 days from the date of receipt. The award becomes enforceable only after its publication. So for the enforceability of award, its publication is essential, its publication is a necessary thing. Then we must say what is the enforceability of award. An award becomes enforceable on expiry of 30 days from the date of publication. So the particular time period is given within which the award will not be enforceable immediately, but the award will be enforceable only after the expiry of 30 days from the date of publication. So that time period is given for any correction or any necessary action for its enforcement. So friends, though this is the time limit which is provided for the enforceability, again the tribunal or the court can give, or it can fix the date for the operation of award also, or in certain circumstances that authority has a power to make or to enforce the award with a retrospective effect also. Retrospective effect means the effect from back date. So now we must see what is the binding nature of award. An award of labor court, industrial tribunal, national tribunal, which becomes enforceable, shall be binding on following parties. So every award have the binding nature, and it binds certain parties. Binding nature means on whom it is binding, on whom the decision of that particular court is binding. So that award which is given by authorities under the act shall be binding on all the parties who are directly parties to industrial dispute. Then it is binding on all parties that are summoned to appear before the proceedings or during the proceedings. It means all those persons to whom court uh, ask for ask to attend the proceeding. Again, all such persons are bound by the decision of court or tribunal. Then it is binding on all the employers, their heirs and successor. It means they, even the heirs and employer successors of employer cannot uh, reject the award given by the court. They have to follow it. It is applicable, or it is binding on all the workmen and the places where the workman is employed. And regarding that, there is an important case law that you must know, that is in M.V. Kuriakose versus State of Kerala. This case was decided in 1977, where the Supreme Court held that an award is a binding on all parties to the dispute or to which the tribunal makes it binding. The parties subsequently may also bound by such award. So parties subsequently means the persons employed in such industry after the decision in dispute. So in this case it was made quite clear that all the persons who are dispute to that parties to dispute, or the persons who are employed in that industry after decision given in particular dispute, are bound by the decision of court, or bound by the award. Next important provision that we must know is the period of operation. Section 19 of the Act provides for the period of operation. According to Section 19, the award shall remain in force or in operation for a period of 1 year from the date of its enforcement. So, when any decision is given by appropriate authority and when it is published and when it becomes enforceable, from that date it remains in operation for the period of 1 year. But in certain circumstances, this period can be extended by the government for another 1 year, and this has to be done by notification in official gazette. But one thing there must be noted, that this period shall be extended only before the expiry of first period of operation. So that government, when it decides to extend the period of operation of award, the government can extend it, but it shall be extended only before the expiry of first period. Now we must see what are the provisions relating to judicial review of an award. See, the general rule is that the award of such courts are free from any review. So this award, the nature of such award by labor court or industrial tribunal, national tribunal, that are final, that shall be the final. It cannot be challenged or it cannot be questioned in appeal or in a revision by civil courts. So this is the general rule, that these are final, these are binding, and these are not appealable. But there are certain circumstances such validity of an award can be challenged. The award can be challenged in a high court under Article 2 to 6 of Indian Constitution, and this can be challenged on the following ground. The first ground is errors of jurisdiction. If the decision is given by the particular authority to which there was no jurisdiction to decide the matter, this is the first ground on which the matter can be challenged, that decision can be challenged. And secondly, where it is proved before the high court that there is a gross negligence of rules of natural justice by presiding officer, only in these two circumstances the award of authorities can be challenged, else it is a binding, it is a final. So friends, these are some important concepts relating to award and its binding nature. So if you like this video, please like it, share it with your friends, and don't forget to subscribe my channel. So friends, thank you.